Welcome everybody. We're just going to give you about half a minute to see if everybody can join correctly, and then we'll start the webinar.
Okay, do you think we're good to go?
Yes, I think we can probably, anybody who's joining a little bit late, I'm sure will catch up. So my name is Karolina Zielinska.
And my name is Angela Piears.
And this is the second webinar in our social housing series this year at 42BR Barristers. So today we will be looking at primarily tenants who say that they're living in a property that they rent from a social landlord as their only or principal home, but actually they're living somewhere else, contrary to the terms of their tenancy agreement. We will also be looking at situations where tenants are subletting the whole of the property, again, against the terms of their tenancy agreement. There are, of course, also other types of fraud, right to buy fraud, succession fraud, but those aren't going to be the focus of our talk today, although many of the points we make now will be applicable to those sorts of contexts.
Yes, we're going to be concentrating primarily on evidence and the starting point really for the talk is that most local authority tenancy agreements and social housing, housing association tenancy agreements require the tenant to be living at the property as their only or principal home and not to sublet the whole of the property. And if either of those two things are happening, that they're not living there as their only or principal home, or they're subletting the property, then the tenant has breached the tenant condition that is covered in for local authorities, the Housing Act 1985, Section 81. And for housing associations, it's the 1988 Housing Act, Section 1.
Now, I know it might seem obvious to some, but why is it so important that a tenant uses the social housing property as their only or principal home?
I think really we're looking at the whole reason why there is social housing. There is social housing because a lot of people need help to have a roof over their heads. And there are a lot of people who need that, and there is a shortage of housing available for that. So we're looking at long waiting lists, shortage of housing. So if someone is saying that they're living somewhere, but actually it's empty and it could be used for somebody else,
yes,
or making money out of a property when in fact the local authority or housing association could use it for somebody who really needs somewhere to live, then that's why it's such a problem and why it's got to be tackled.
Absolutely. So in terms of, I suppose, realizing that there is tenancy fraud occurring, there are a couple of red flags, certainly, that I've come across in my practice that should hint to social housing providers that there's something more going on. First, I would say a big red flag is non-engagement with a landlord. So not responding to calls, texts, emails, when invited for interview, just ignoring those letters. Not engaging with gas safety checks or necessary repairs that need to be carried out at a property. That's quite common in these sorts of situations. Similarly, of course, any discrepancies in the address provided to the social housing landlord obviously are a massive red flag in and of themselves. Sometimes tenants will provide different addresses for different purposes, and that can give you a starting point for investigating tenancy fraud. Also, discrepancies in documents provided. So if it looks as if you've altered a document or that the document might not actually be a true document, deliberate cutting off of part of a page, something like that, some forms of forgery are more obvious than others. But that again can be a red flag for some sort of fraud occurring. I would also say contact from either neighbours or subtenants is another big red flag. So neighbours, of course, going to be complaining about what might be going on at the property, whether that's having lots of people visiting because of short-term subletting going on, or not recognising the neighbour anymore, or having problems with antisocial behaviour. And with subtenants, it may be that they are contacting, say, a social housing landlord to work out how to pay their rent, when actually they're not the ones on the tenancy. Often that's how they find out. It is rather unfortunate. A slightly more subtle red flag that I've come across is unusual wear and tear at the property. So if you've rented a one-bed flat to one person, but actually you go and visit after 2 years and it absolutely looks like a truck has hit it, then we might be dealing with a situation where the flat's been let on a short-term basis very frequently, and so the wear and tear has been more than one might otherwise expect. Maybe it's been let illegally to a larger family than what it's suitable for. That itself can be a red flag. And finally, mounting arrears. So often in cases, particularly of key selling, where a person might obtain a social housing tenancy and then they sell on the key to a subtenant, and then just abandon either the country or the property, they will not be concerned with paying council tax or rent. So the arrears for those items might mount considerably in a short space of time, and that might also indicate tenancy fraud. Changing the method of payment as well is quite common in those situations. So maybe moving from a direct debit to a cash basis for payment of rent, because again, perhaps the original tenant no longer wants to be associated with paying the rent or the property. So I talked a bit there about what might give people suspicions. Yes. I suppose now, Angela, we come to what do we actually do if we want to take action against someone we suspect of tenancy fraud? What can we actually do?
Well, the main action, I suppose, in the civil courts is to take steps to take possession of the property.
Absolutely.
And in order to do that, you need to build a case. So you need to be able to establish whether or not the tenant is using the property as their only or principal home. So you've got the red flag, you're acting on it, and now you need to actually gather your evidence to establish whether or not they have broken the tenant condition. And of course, if you are satisfied that they are not living in the property as their only or principal home, then you can serve a notice to quit and obtain mandatory possession. Although, as we'll discuss later on, that isn't necessarily the only thing that you can do in order to ensure that you've taken all steps to gain possession of the property.
Absolutely. And I think you mentioned to me prior to this recording quite an interesting point. What happens if a tenant moves back in after a notice to quit is served?
Well, if they are still living, if they have moved back into the property,
yeah,
and they are there when the notice to quit expires, then that's it. You cannot rely on your notice to quit, which is why actually, if you have, as you've suggested, say mounting arrears, that you serve a notice of seeking possession based upon arrears, so that you've got something to fall back on if the tenant realizes what's going on and moves back in. And it is surprising how even when you have got a case where there were lots of people living in the property and the tenant was nowhere to be seen, all of a sudden when the notice to quit has been served, the tenant moves back in and all of the people disappear. So it does happen.
Yes. So it's about really then being careful with your wording, whether you choose a notice to quit or a notice of seeking possession. And if you go for the latter, making sure you include any other possible grounds that might justify ending the tenancy, whether that's not notifying the social landlord that you'd be away from the property for a really extended period of time, whether that's rent arrears or something else, just making sure you've got that evidence. Does that sound about right?
Yes, I would do both to protect your position. And I would say that so often in the tenancy conditions, you have got a clause that says you must tell us if you are going to be away from the property. And quite often that's left out of the notice of seeking possession. But it's a useful one to have there because you need as many things as possible to build your case upon.
Absolutely. So you talked there about building a case. How best do we build a case in these sorts of instances?
Well, you need facts. Judges like facts. Facts, can, obviously there can be many different arguments and interpretations of things, but the more facts you have, the better. And therefore you are going to need somebody to collect the evidence from which you can elicit those facts. And that is either going to be really your housing officer or fraud investigator, or best still, the housing officer working with the fraud investigator, so that you have got very, very, very good information about what has happened at the property, and you have got an inquiry that has exhausted as many avenues as possible to prove to the judge what has happened.
Absolutely. And I suppose, what stage of that process would you expect your fraud officer and/or a tenancy officer to get involved, really?
So you mentioned in the red flags about a neighbour complaining. I think that is more often than not the trigger that starts things off. The housing officer gets a complaint from someone, and then they may make a visit to the property, see something, for example, signs of no life, or maybe talk to the neighbour on an anonymous basis, obviously, and then contacts the fraud investigator to say, I think we've got a case here where that needs an investigation, where there's going to be some fraud to be looked at. And then when you're then preparing your case for trial, you can have witness statements from both of those officers, and that will make a very strong case.
Absolutely. So in addition to, I suppose, evidence of visits to the property and those sorts of conversations that might be had with neighbours or tenants, I know that interviews are often undertaken, whether under caution or no. What benefit do those sorts of interviews with tenants carry?
So if your tenant is actually there at the property and you've either invited them to come down to the office for an interview, or you're interviewing them at the property, if you're the fraud investigator, let's say, and you know that a criminal prosecution is being contemplated, then an interview under caution would be undertaken, and that has the advantage of being recorded. A transcript can be provided and attached to your witness statement, and it can be relied upon in the civil proceedings, whether you go for a criminal prosecution or not. So there you would have an absolute record of what's been said. If you're not going down that avenue, and you don't want to be recording it, you don't want to be doing it under caution, then I would say make a note of what you have asked. Make sure you have a record, type up an attendance note, attach it to your witness statement, because just referring to a comment that was made in your witness statement is not going to carry as much weight as an attendance note made contemporaneously. Tenant themselves can dispute what was said in an interview, but if you say, no, I have made as accurate a record as I possibly can, this was taken from my notebook, or as I said previously, it was from a recording, that cannot be disputed.
Absolutely. And I think particularly if it's signed by the tenant themselves, although I appreciate they're not always willing to do so. Regarding then perhaps language, I understand often there is a language barrier in these sorts of cases. Do you recommend that, I suppose, social housing providers be proactive and arrange interpreters?
I think that where language could be an issue, is always going to cause a little bit of a problem. So quite often you would get a witness statement from an officer that makes no reference whatsoever to whether it was easy to have a conversation or not. And then later in proceedings, the tenant makes files and serves a defence, says that they didn't really understand what was being said, says that an interpreter is needed, and there is absolutely no evidence to gainsay any of that. So if language is or isn't a problem during that conversation or interview that takes place at the property with the housing officer or fraud investigator and the tenant, record whether or not it was there was any language barrier, because then you have always got that as a reference. That obviously the tenant can dispute it, say, well, I may have looked like I was understanding and conversing easily, but in fact I really struggle. But there are so many things that crop up with these cases that are just question marks, you're not sure about this or the other. The more things that you can be as certain of as possible as you go along, the better, really.
Absolutely. I think if there's one takeaway from what we've discussed so far, it's document everything as much as possible and in as much detail as possible as a general rule.
I would also say that whilst we were talking about complaints from neighbours earlier on, that whilst a neighbour may wish to be anonymous, and certainly at first contact with the neighbour, probably it's sensible to say, I'm not going to reveal who you are, but to anyone, particularly to the tenant, but I would like the information from you. However, if that neighbour has seen or heard anything that is particularly useful, it may be that in fact a witness statement from that neighbour would be of assistance to your case. Now, if they do not want to make a witness statement and sign it and then potentially go to court, absolutely fair enough. But make sure that perhaps if they say something, you can write it down as a quote and say that you'll anonymize it, but that this is a quote that was given, so that you've got as much reliable content for your evidence as possible. So if they were willing to give a witness statement, absolutely great. If not, can you write something down that you could put in as an anonymous statement about what it is that they've seen?
Absolutely. Thank you for that very comprehensive description of both witness statements from tenancy officers, fraud officers and neighbours. I think it is important to make sure that, again, when collating all that evidence, it's as varied as possible and as thorough as possible, as you said. So
now, I think we're moving on now, aren't we?
Yes.
I'm interested in the evidence that we're going to be collecting, because we've got our witness statement, but we need information in that witness statement.
Absolutely.
What is it that we're going to be looking at?
So there is a range of other information that I would certainly encourage social landlords to collect and include in these sorts of witness statements that isn't just oral accounts of what's happened. There will be disclosure from third parties. That can include the police if there's been complaints about antisocial behaviour, the DWP if there's been any issue with benefits or payment of benefits to a person registered at another address, for example. Airlines can be also a useful point of call. One can request the details of flights in and out of the UK, which is particularly useful if you suspect a tenant's living abroad. This information can be sought under the Prevention of Social Housing Fraud Power to Require Information England Regulations 2014, very catchy title there, which does allow local authorities to request that sort of information from private sector organisations, specifically for the purpose of investigating social housing fraud. So they can also talk to not just airlines, but banks, building societies, companies, people whom you might have gas and electric contracts with, a really wide range of organisations there who can give you more data that might support your case. But there are also other places you can get that data that might be closer to home. So, for example, some really key information that can be collected perhaps by local authorities themselves includes evidence of being on the electoral roll. Now, it is becoming more common for those who are perhaps more wise when committing these frauds to just not sign up to the electoral roll. But certainly that's something worth checking to see who's been registered at a property. Subtenants might not have been aware of fraud going on and might have signed themselves up regardless. That can help to prove your case. Local records are also really, really important. Even records that might seem insignificant can actually provide the best information. So certainly I've seen cases before where information from even library cards has been used in these sorts of housing fraud cases, parking permits, parking tickets, council tax accounts, whether you're receiving a single person discount or perhaps some sort of student exemption when actually that doesn't match up with the details you have of the tenant on file. Bus passes, blue badge applications, taxi driver licenses, all of this stuff is really key information that might show some sort of discrepancy in the picture the tenant is painting to the court.
And in fact, the local authority might be able to access all of those itself.
Precisely, which saves on cost, quite frankly. There are some commercial services available that might be of assistance. First, with regards to tracing of addresses, it is always available to a claimant in these situations to employ a tracing service. I will talk about that slightly later on in more detail, but essentially, if the defendant has links to property elsewhere, but you're not quite sure of what that property address might be, that's a good place to start. It is relatively inexpensive for the utility it provides. If you know the address that you think the tenant might be residing at, whether it's that they own a second home or that they live with a partner elsewhere, could be worth trying to purchase the deeds of that property via the land registry. Particularly if it's a leasehold property, you can get a lot of information regarding previous addresses from that. Often it's somewhere in the lease. So worth looking through in some detail. Similarly, when we're talking about paid services, getting a credit check can be a really important piece of evidence. But, and I'm sure you've probably had the same experience, Angela, I've seen far too many credit reports presented to court without any explanation. And quite frankly, that doesn't help anybody. So in those cases, would you recommend perhaps that's something that the fraud officer goes into more detail about?
I think that's absolutely a really, really good point. The witness statement can actually try to draw out that key information from the credit report, because otherwise they can be voluminous, can't they?
Absolutely, and half of it's irrelevant, to be perfectly honest. You need to draw out what you say is the actual evidence of fraud, whether that's a pattern of behaviour over a longer period of time, lots of different people having credit registered at a particular address. That is itself suspicious if it's a one-bed flat, for example, that's only suitable for one person, or whether you have a particular individual who you believe to be the subtenant who's been linked to that address, again, for some time. Just point out what part of the credit report you're relying on and make it clear why that's relevant.
I know it's an aside in a way, but if you have paginated your witness statement and exhibits, you could potentially actually refer to which page it was on, because they are voluminous. And even if you draw out those salient points, it may be quite tricky to be sifting through to find which section it is. So that's another point to bear in mind. Make sure that your evidence is actually easy to understand and easy to find the relevant points.
And it certainly just increases the likelihood that you'll be able to confidently get possession at a first hearing, as opposed to having to go through quite a long process if the evidence is very well presented. So I suppose finally, the most crucial other form of evidence that you may wish to rely on is evidence that comes from social media, whether that's professional or private social media. If it's a public account, you can search through historical posts and that sort of thing for any evidence of either residence elsewhere or that, I suppose, non-primary residence at the social housing address. It is worth checking professional social media too. It can be relevant tangentially. So can you see that the defendant is working out of the country? Can you see that, I suppose, they are linked with organisations that mean they cannot be living in a particular area of the country regularly or otherwise? it is really important, again, as we've said before, to be absolutely methodical in documenting this sort of evidence. Social media pages change. What was once public might be made private, particularly once a tenant is aware of the investigations that are ongoing. So it is important to take screenshots or save web pages with clear evidence of when that page was screenshotted or saved, and at what time. And to check back to those pages to see if there have been any updates. Those updates may themselves be crucial. It is a very fluid form of evidence, and so again, it's just necessary to make sure that you're keeping an eye on it as you build your case. I've mentioned social media, but also property websites such as Airbnb serve much the same purpose if we're dealing with cases of subletting, making sure that you check again regularly to see if you can use those sorts of sites to collate further evidence. And finally, perhaps key fobs, slightly unusual one there, but I've certainly seen this come up in past cases. If you have some sort of door entry system on a block of properties that is personally identifying in some way, again, that can help build a case against or a particular resident who you suspect of subletting or of tenancy fraud. If there is a duplication of a fob without permission, if the fob's being used at certain times of day that you might deem suspicious, again, it either provides a red flag or can help you build evidence in these sorts of cases.
So you're saying that the tenant may request new key fobs?
Yes, let's say they request 4 and it's a one-bed flat. Already that's a bit suspicious. But equally time of day. So it might be that I suppose maybe the patterns of the key fob change significantly, such that you suspect there might be something else going on. Renewing key fobs is also a great opportunity in and of itself to try and identify tenancy fraud. It gives you an opportunity to perhaps re-request ID from those living within social housing properties. And at that point, it might be easier to identify who within a block might not be the original tenant, but that is perhaps a secondary value. So Angela, any final comments then really on pleadings in these sorts of cases?
Well, I think the pleadings really do need to be as clear as possible. They do need to contain the salient facts as you see them and as you want the court to agree with you. And the evidence itself needs to be also extremely clear and direct the court to the exhibits in a very clear way, so that your case, there can be no doubt about it. You've cited the dates, you've said what happened, and you have left basically the court in no doubt about what is going on at that property.
As you said earlier, really, there's never any gotcha sort of evidence in the vast majority of these sorts of cases, although of course some of those circumstances do exist. Really, it's about building that picture to the point at which it's undeniable that something unusual has been going on at the property, such that either it forces the defendant to concede as early as possible in proceedings that actually it's easier just to give the keys back.
Yes, and that they haven't been using the property as their only or principal home, or subletting, which is probably amounts to the same, that you have not used the property as your only principal home, and therefore you've breached that tenant condition. And that's what you're always trying to hammer
home, I guess.
Yeah. So what remedies other than possession are available to social landlords who suspect tenancy fraud?
Well, if we deal with the civil context first, possession is, as you've said, the crucial remedy, but other remedies available to social landlords include unlawful profit orders and perhaps seeking an order relating to a form of unjust enrichment. Both of those remedies allow you to recover monies that might be made by a tenant who's unlawfully sublet a property or committed tenancy fraud. I should say the key really in unlawful profit orders, if we start there, is of course profit. I know that seems obvious, but it is really important to state that at the outset, because crucially, rent and other expenses that might be incurred normally by a tenant and paid to a landlord do not form part of an unlawful profits order. It is any money received over and above that amount that could be considered by the court as forming the basis for an unlawful profits order. It's defined in legislation, primarily Section 5 of the Prevention of Social Housing Fraud Act 2013 is going to be the bit of law you want to look at. It details in its various subsections the steps that the court will consider when looking at whether to make an unlawful profits order. For the sake of time, I'm only going to outline those briefly, but Section 5 is the key provision worth having a look at after this webinar. So at subsection 2 there, it defines an unlawful profit order as an order requiring the tenant against whom it's made to pay the landlord an amount representing the profit made by the tenant from the conduct described again in that section 5, subsection 3 and 4. Essentially, it is profit made by renting out the social housing property. Now, the court will order in those sorts of cases what they think is appropriate. That's quite a general test, just based on the wording alone. But that is because often it's very difficult to collate evidence of actual profit. And so the court has to do some guesswork. They will look at any evidence that you are able to provide as to what profit was made, but they will also consider representations made by the landlord and tenant at any hearing or in writing, because it may be that the tenant's financial circumstances have changed drastically such that it would be very unjust to make such an order. There can be any number of relevant factors. It's a very wide consideration the court has here.
And how do you prove it? How do you would you need bank statements to do that?
Yes, so bank statements, as before, can perhaps be sought using the same legislation that we referred to earlier. A local authority can request that kind of data from a private provider. But equally, it might be possible to, I suppose, put the tenant on notice that you're seeking this sort of order, and the court might be willing to draw conclusions if they refuse to provide certain documentation, although I'd be cautious about going too far with that. I think that is also something maybe worth raising in those sorts of hearings, because certainly it's suspicious conduct on the part of the tenant if they're unwilling to disclose anything themselves, and the court ought to be able to draw adverse inferences in those circumstances.
I suppose if you've actually managed to speak with and establish a relationship with the subtenants,
that can help too. Yes,
documentation.
They'll probably have been paying rent for months even, and so they might be very willing to say, yes, look, you know, this person scammed me, I paid them a deposit and I don't know where it's gone. You know, and then you can collect that sort of evidence going forward for the purpose of an unlawful profit order. I always plead this as a backup, but in the event that it's not possible to meet the test for an unlawful profits order for whatever reason, you can plead either separately or in the alternative unjust enrichment. So the key there is that you have to show that the defendant has been enriched, so that the tenant has gained something by having the tenancy, here presumably market rent for the property rather than a lower social housing rent that they've been paid by a subtenant. Secondly, you as the social housing provider need to suffer loss as a result of that behaviour. Here, the key loss is you've not been able to rent that to someone else. That property could have gone to another family in need, and now it means you've had to meet your housing duties with less available housing stock. So that's how we fulfil that part of the unjust enrichment test. And then thirdly, we need to show that the tenant has been unjustly enriched in some way. So here they have unjustly been enriched because they didn't require the accommodation that they have used for profit. And so they ought to be liable for the value of the enrichment. So again, any profit that they have made from subletting. So that order will cover money that ought to be received by the landlord in addition to rent and any use and occupation charges payable at the property. Again, really, it's concerned with profit rather than the base rent. That can be dealt with separately. So those are the primary alternative civil remedies. we discussed before, I suppose, the utility of serving both a notice to quit and an OSP in the right circumstances.
Yes.
If we're dealing with leases, forfeiture might also be available, subject to the terms of your lease. And criminal proceedings are, of course, always a factor worth thinking about in this kind of context. What sort of, I suppose, criminal remedies might be available? How might landlords approach that sort of possibility?
Well, the first thing that you need to remember with criminal proceedings, of course, is that it's a higher standard of proof, which is why, as we were saying, when you're dealing with the interview of the tenant, if you are thinking of a prosecution, the interview needs to be under caution and needs to be recorded so that you've got the transcript, because it's that higher burden of proof. There's no on the balance of probabilities. You've got to prove it beyond reasonable doubt. So you can have a prosecution under the Prevention of Social Housing Fraud Act 2013. Section 1 sets out that subletting social housing is a criminal offence, and unlawful profit orders can be sought in civil proceedings. So that sort of runs alongside the civil and the criminal, but you can pursue the criminal prosecution under Section 1 of POSHVA, as I think the friendly name of the act.
I like that acronym.
Yeah, it's kind of cute. Then there's also Proceeds of Crime Act 2002. So if you're found guilty of unlawful subletting, you could be fined in the magistrate's court, and you could be tried for a second offence of unlawful subletting and acting dishonestly in the magistrate's court or in the Crown Court. So serious offences. I've not been involved in either of those. I don't know whether you have.
I haven't been personally involved yet, although I should perhaps add at this stage that insofar as unlawful profits orders and unjust enrichment is available as a remedy in civil law, that's enforceable only to the extent that those remedies haven't already been awarded in criminal proceedings. So unlawful profit orders can be made in the criminal context too. And it's important that so far as possible, you try and make sure there's no overlap there. Or if there is any overlap, again, can't be enforced to the extent that that is the case.
That is important to stress. And of course, you know, it is possible to have a prison sentence in the criminal courts, although I think that dishonesty there has to be proved in order for a prison sentence to be effective, because it is obviously so serious.
Angela, now we've had a look at, I suppose, the civil and criminal remedies. If we roll right back to the start of our talk, how would you recommend that social landlords discourage this kind of tenancy fraud in the first place? What preventative measures can be taken to try and avoid this arising?
It is difficult, and sometimes, obviously, things happen that you know, as out of the best of reasons, really. Maybe somebody is very hard up and they need to make some extra money, or they happen to have visited family, and then there have been some incidents which have meant that they've stayed longer with their family than they had intended, and before you know it, that then a more serious situation develops, because they've taken steps to perhaps have someone in their home, and they're maybe hard up. Anyway, so there's many sort of understandable reasons, as well as
bad actors.
Yes,
deliberately trying to create the situations where they're exploiting the social housing system.
And I think it's important to bear that in mind. And I'll stress that when we come on to the last point in this list that I'm going to go through. But one of the ways to discourage tenancy fraud would be to encourage those in the community to report any issues. And that can be from a perspective of simply making sure that there is, general peace and quiet. So if there is antisocial behaviour that neighbours are disturbed by and unhappy about, to encourage the reporting of incidents, equally unusual comings and goings. So if you've got a good relationship with the neighbourhood, community reporting is a good way, as we said right at the start, to set off those warnings.
And making it as easy as possible, having a single point of access for those sort of reports really can streamline the process and make sure you get those the reports acted on as soon as possible.
Yes, all of that. I think, to have a system in place, very vital. One person who people know to contact, and then a system in place so that whoever makes contact knows that action will be taken.
Precisely.
The other side of that is to regularly check on the tenancy, pay visits to the property, make appointments with the tenant, carry out what in effect might be a tick box exercise, with small boxes for comments even, but so that you've got a form that you've filled in to say, I've checked on this tenancy, I've asked the tenant these questions, and then you've got a record. Is it the same person you were talking to as when you visited last year, for example? Is the signature the same? Get the signature of the person, all of that sort of thing. But it also means that if you are inside the property, you can look around. What does it look like? Are there any changes? Is it lived in even? And you can ask for ID at the same time. So that is obviously an excellent way of being on the ground, finding out. And
we should perhaps say, when it comes to tenancy checks, certainly a problem I've seen raised in previous matters is that social housing providers feel restricted in the hours that they can visit tenants because of the hours of their employees, and sometimes simply tenants are always out whenever they go and visit, and sometimes that is because the tenants are behaving suspiciously, and sometimes that's for perfectly valid reasons.
Because they're not.
Yes, they just have a job that has long hours, perhaps. In those circumstances, I would recommend that either the social housing landlord consider subcontracting if possible, if it's not too prohibitively expensive to do so. It might be that hiring somebody who is able to work different hours would assist with that problem, and can visit the tenant at slightly more unusual hours to actually make contact with them. Alternatively, just being a bit more flexible with your existing terms when it comes to this sort of work that you're engaging your employees for, can allow for perhaps those visits to be undertaken at more unusual hours.
Maybe in the evenings.
Yes. When I say unusual hours, I'm certainly not talking 2 a.m, but just say 6:30 p.m. as opposed to 5 can make a lot of difference.
Yes. I think that one point that's quite important to stress is to clearly communicate any rules and consequences to tenants, so that if anyone is considering not using their property as their only a principal home or subletting, they know what the consequences of it are likely to be.
I think it's fair to say the notion that all tenants read their terms and conditions of tenancy is quite artificial. Unless they're particularly legally minded, I would be surprised if they'd read them in detail. So really it's a question of awareness to some degree.
Yes. So clearly communicate those, summarize them, sending out a letter, or I know that you've done some research on what local authorities are doing sort of throughout the country.
Yes, so Bristol City Council introduced an initiative where they, I suppose, provided an update on what you were and weren't allowed to do with certain types of social housing tenancy in their local magazine, Our City, which went out to most residents. That can be a really good way of again, raising awareness, campaigning to ensure every tenant in social housing understands what the limits of their tenancy are, what they are permitted to do or not. Certainly there have been some quite creative approaches to dealing with this sort of problem. Practically speaking, what most social housing providers want is the property back in these sorts of circumstances. And Harrow Council, for example, introduced a 2-week amnesty initiative where, provided keys were returned in that period, they agreed not to prosecute in these sorts of social housing fraud cases. So I think it's worth really reevaluating what your objectives are in trying to eliminate this sort of behaviour. If your priority is just to get the property back, that could be quite an attractive option in order to avoid the need to go down a protracted legal process.
Yes, and so that's what one of the things I was thinking of at the beginning of this section when I was saying, well, some people simply get into a problem that they hadn't really meant to, and they just needed some extra money or whatever. An amnesty might be actually quite a good idea.
Yes.
Don't worry, there won't be expensive litigation, there won't be a difficult prosecution, but you've broken the tenant condition, and therefore there's an amnesty. You can just
work quite well in cases where the tenant has a second property that they're actually living in and is subletting the first. There's no issue for them as to where they'll be housed. It's just a question of extracting themselves from that situation with the least liability possible. So that is an attractive proposal from their perspective. So, Angela, I suppose in the interest of time, we can perhaps make our final points on this topic. I've seen a number of cases where subtenants get caught up in fraud unwittingly. How do you think that social landlords ought to deal with subtenants in these sorts of cases?
The subtenant really, I think, as we referred to earlier, could be of great assistance when you're building your case. And I've certainly dealt with one case where the subtenant did give a witness statement, did provide very valuable evidence, and did come to court. So that was, I think, a fairly unusual situation, but it does happen. And obviously, if your attempt to contact them and communicate with the subtenant is not hostile, for example, you may be able to get access to the property that perhaps you wouldn't have been able to if the approach is more aggressive. I mean, it's difficult. Everything is dependent on the circumstances. But for example, the case that I was talking about, the subtenant allowed the officers into the property. Photographs were taken, including a photograph of the cupboard where the actual tenant had just left a bin bag of clothes.
That's very helpful. So
there was absolutely nothing of their property left there at all, except for this
just a bin bag of clothes. Fair enough. No, I can see how their assistance would be invaluable in certain circumstances.
And obviously, you can then also see from that there are no, for example, photographs of the tenant and the family, but in fact, plenty of photographs of the subtenant family as well.
Of course, yeah.
You can obviously check their identities, taking photographs of their passports.
Yes.
And the other point that we also discussed earlier, asking questions about, how do you pay your rent? To whom do you pay your rent? how is that rent paid? Is it in person? You're saying in cash? Is there a rent book, etc., etc.?
No, makes perfect sense. Really, their value is evidential primarily, and in terms of dealing with them, I suppose their interests are inevitably tied to the interests of the tenants, insofar as you serve a notice to quit or a NOSP, and that affects the tenant's tenancy.
Yes.
One issue I've actually had come up a number of times in these sorts of cases, which I think might be a nice point to end on, relates to the service of documents on a tenant who you suspect is no longer living at their social housing address. A number of judges I've been before recently have picked up on this. If you are serving documents, particularly the claim form and associated documentation, in circumstances where you really believe they've left the property, then specifically Rule 6.9 subsection 3 of the CPR applies. Where you have reason to believe that that person no longer lives there, then you need to take reasonable steps to ascertain their new address. It doesn't matter if you can't find the new address at the end of the day. We'll come on to that in a second. The key is just that you're trying to find it. And so again, as I referred to before, it's possible to engage agencies who can do a bit of investigatory work for a nominal fee. And that usually is enough to satisfy the court that you've made those reasonable efforts, taken those reasonable steps to find their new address so you can serve them correctly with the papers at that new address. The address is the gold standard, but if that's not possible, if you can't obtain that, then you can seek permission to serve the papers via an alternative method, such as email, or at the last known address, so at the social housing property itself. I think it's just a key procedural step that a lot of people miss. You do have to try and find the new address when serving court papers, if at all possible. Taking those reasonable steps is really important.
It's not always going to be easy, though, is it? I mean, it could be. Where would you start?
Precisely. And if there really is no way that you could get any information, then fair enough. But certainly in circumstances where you might have expected it to be obvious that you could just serve by email or something like that instead, where you've got no forwarding address and no idea which borough this tenant's moved to. I have had an increasing number of judges require at least the engagement of services of a tracing agency, in the payment of between £10 and £30, just for them to make some effort to try and track down this defendant, whether that's by looking at social media, whether that's another method, I can't say, but it's just for the sake of satisfying that provision of the CPR, some sort of reasonable steps need to be taken.
And in order to satisfy that, would you need a witness statement, certificate of service? Where would that information be in order to satisfy the court?
I think different information is going to be provided by different providers. I've never had direct contact with one of these agencies, but certainly I would recommend that either the information they give you is incorporated into a witness statement, or perhaps even the particulars, if they've given you some sort of certificate or documentary evidence of what they've done. And that can be either, again, appended to this particulars or described in a witness statement. It doesn't have to be from the person who's doing the investigating, if they're tricky to get hold of or it's going to cost too much. But certainly that evidence should be reproduced at minimum by a housing officer or in the particulars.
And because that would satisfy
precisely.
Yeah.
Absolutely. So with that, I think we should perhaps get to some questions.
Yes.
I think we've got a bit of time now. We'll just have a look through what's been sent in.
It looks like we have a few questions.
So I can see the first question is there a need to serve the notice to quit and NOSP? I think we've probably addressed that thus far in the talk. That one may have been asked before.
Yes, I would say we're not talking about a need, we're talking about protecting your position. So the full question says we've tried requesting information from a bank. All right, so that's a separate question. So yeah, so NTQ and NOSP, not a need, but actually probably quite a good idea. Caroline, do you want to?
I can see there's a question there about
they've tried requesting information from a bank.
But the bank refuses to provide the information. I think often what private organisations are concerned about is the GDPR. So if you can assuage their concerns that what they're doing is legal in providing you this information. So if you set out really clearly an explanation as to which bit of legislation you're relying on, and why you believe that there is some sort of social housing fraud going on, and that requires them to give you the information. And I would also, again, in that email, perhaps correspondence, flag the issue of GDPR and say, look, you are permitted to give me this information regardless of what you may otherwise think. That can go a long way, because often the issue is that the bank just doesn't routinely receive such requests. Perhaps that individual who's dealing with it hasn't come across this legislation before. And so starting there can be really useful.
Yes, I would agree on that.
I can see there's a question about REPA authorization. I've not dealt with that personally myself, but certainly I think my preliminary view would be if it's public information that's been put out there by a tenant, it makes perfect sense to collate that as part of an investigation. I appreciate there might be some sensitive material within the data that you're looking at or collecting, but really what you're going to be documenting is going to be anything related to social housing or residents in a different location, or renting, and really, I suppose, the amount of and purely personal information that can be included within that is a bit more limited.
And the question is, would you need to consider REPA authorization for directed surveillance to routinely look at social media accounts and take screenshots? And I think what we're not actually talking about routinely looking at it. It's if the set of circumstances leads you to believe that that would be a useful form of evidence, then to look at the social media account. But I don't think you'd be sitting on it day and night.
No, I suppose what I meant when I said keep checking is definitely look at social media as part of your initial investigation, and perhaps as court papers are served, or as you get to, well, as it's made clear to the tenant that actually they are under investigation, that something is happening, at that point it's often worth checking again, because that's when accounts might be privated, posts might be removed, and that itself can prove evidence of tenancy fraud. I can see that there is a question, somebody has said where they've told the fraud investigator to obtain information from airlines, the fraud investigator often doesn't want to contact them. Really, the provision to cite is the one that we've relied on thus far. I can repeat that again. The Prevention of Social Housing Fraud brackets power to require information brackets England regulations 2014, statutory instrument number 899. That is the only thing you'll need to cite in those sorts of instances. Again, as before with the bank question, you might want to be alive to airlines' concerns around GDPR, but reassuring them, setting out clearly which part of those regulations you're relying on should go some way in leading them to disclose that information to you.
Yes, and stress the reason why you're asking, really, and that you're relying on those regulations, and that it's for limited, restricted purposes. There's also an interesting question here about how old your notice to quit can be.
Yes. Weirdly, I've seen quite a few cases where social housing providers will reserve notices to quit, even though they know they don't need to, precisely because of this concern that there might be some issue with it being too old. And in those circumstances, I'm led to sort of pleading reliance on the original notice to quit, but then in the alternative, all the others, just out of an abundance of caution. Certainly my view would be that the original notice to quit is valid. I think if there's been a delay in bringing proceedings, that needs to be explained by the claimant, because it does go, I suppose, towards any defence in saying actually there might not have been any real evidence of tenancy fraud at that stage. And if you've not got something more since, and that was that justifies you taking it further than just serving the notice to quit, you've not got a very strong case, have you? So that's the real risk there, I think.
Of course, the original notice to quit may have had some defects in it, so that would definitely be worth checking. And what has happened since the expiry? Has the tenant moved back in?
Yes.
Obviously, if they moved back in after the expiry, then you could say, oh, well, you know, it's a slam dunk. They weren't there when it expired, and therefore, you know, the tenant can, you know, the tenancy has been brought to an end. But as can happen, the tenant may have a good reason why they were not at the property, and they did have an intention to return, and so then you would have a wholly interesting set of proceedings all about whether or not they their intention to return was valid, whether the facts all stack up. So it's always more complicated than it first appears. But I would say, really, if there's no defect with your notice to quit, then you could probably rely on it. And I've not dealt with a case where a tenant's run a defence that it's too old.
I can see, actually, on talking of tenants running certain defences, just to take a question out of order, I've got a question here that states, to what extent has a tenant ever run a PACE Act defence to an interview under caution? So this is a possible defence that's available in criminal proceedings if an interview under caution is not PACE compliant. It is a risk, and hence it is very important that interviews are, so far as possible, PACE compliant. It is something that perhaps social housing providers ought to be alive to if they intend to rely on that interview under caution in subsequent criminal proceedings. It is not as relevant in the criminal in the civil context. No. Apologies.
But your fraud investigator should be absolutely and utterly properly trained. If they're even contemplating doing an interview under caution, they must know what they're doing and how to go about it. Another question, have you ever had a case
where a tenant sought legal advice for a solicitor to attend the interview under caution with them, and if so, would representation be available? I would assume that representation in an interview under caution would be under criminal legal aid provisions, which I can't say I'm hugely familiar with as a civil lawyer, but that would be certainly my best estimation of that one.
And certainly if the tenant wanted someone to be with them during an interview, I think that they request should be acceded to.
Yes. But I appreciate it's rather uncommon for representation to be requested in those circumstances. Often tenants aren't quite aware at that stage of the possible consequences of the interview, in all honesty. So
some interesting questions there, though.
Fascinating things to think about. If we have any further thoughts on that, we'll update the description of the webinar. But thank you all for attending today. The recording will be available shortly on the Chambers YouTube channel and on our website. And again, as before, we would be grateful for any feedback you may have on the webinar. The next session in the series, Angela, I think you have some more information about that.
I do, yes. And it is going to be on the 5th of November. And Desmond Kilcoyne and Matthew Tim will be examining several typical types of scenarios where a fraudulent succession claim is made and the application of the relevant legal tests to those cases. For example, whether a tenant in hospital who has serious illness satisfies the only or principal home test, and whether a would-be successor satisfies the residing with test. So I think we'll definitely be watching that one, because that complements and follows on nicely from today's webinar. So that's the 5th of November to put in your diaries.
Thank you all for joining us today. Have a lovely rest of your evening.
Bye-bye.